Welcome to the start of 2 special episodes. We're flipping the script for the next 2 episodes as I hand over the mic to my friend Sheila Wilkinson for a complete podcast takeover. Sheila's a lawyer and the voice behind 2 fantastic podcasts, Managing Client Disputes and Building Your Joyful and Thriving Lawyer Life. Sheila helps lawyers and service professionals tap into who they really are, figure out what they really want, and create a roadmap to get there. Today, Sheila's putting me in the hot seat, so buckle up for a different kind of conversation as Sheila takes the wheel and I spill the secrets behind the consultant curtain. Sheila, the show is yours.
Okay, here we are. Today I am interviewing Elizabeth to get into the real nitty-gritty of why she does what she does. As a host of 2 podcasts myself, I know how easy it can be to gloss over our own genius and things that might seem like common sense to us or second nature to us can just kind of, be hidden in the little cracks of the things that we say. So my job today is to dive into those little things that make Elizabeth. So Elizabeth, welcome to your show.
Welcome to my show. Yes. Thank you, Sheila, for joining my show. That's right.
Thanks for letting me take over. I've always wanted to do a podcast takeover. This is actually my first podcast takeover. Hopefully it will not be my last.
I am very excited that you're taking over my podcast, and I'm glad to be the first.
Yes, I know. We love being first, don't we? That's a whole thing. That's not the topic of today's conversation. Well, maybe it is the topic of today's conversation. Actually, it is actually, I think, maybe the underlying theme for today. So, I've known you for a while, and I swear, for those of you who are listening, she is not putting me up to this, I swear. But I would be lying if I said that I didn't think that you were a genius, right? Like, I think you are a genius, Elizabeth. Like, every time I talk to you, I learn something new and you blow my mind with something. I'm like, what? How did I not know that? So, I think you're really amazing. She's not putting me up to this, I swear. I think your energy is really contagious. Yeah. I think you have a really powerful transformational energy about you. You see the cyclical nature of the legal profession. You have an innate sense about things, like the way that you want to share all of your experiences and the way that you want to support other lawyers. Most lawyers are doing it because they're trying to get something for themselves. But I think you and I are similar in the way that, we actually genuinely care about other lawyers and we genuinely care about making the profession better. So, that warms my little heart.
You can take over my podcast anytime.
Thank you. I think I might. Yeah. Maybe we should do this once a year or something. I don't know. I don't know. I just think that you see things that are always changing, right? In the law, litigation, technology, the laws, right? But at the same time, at the heart of our work as lawyers, it seems like you truly actually understand that the one thing that doesn't change is people, right? Juries, judges, other lawyers, witnesses, plaintiffs. Yeah. It seems, I don't know. That's what is the saying? The more things change, the more they stay the same. Yeah.
Yeah. Human nature is fascinating. And also, pretty much every time I see a post or see somebody talking about decision making and it's emotion based, I'm like, well, duh. But again, it's not a duh to everybody. So I'm glad we're going to talk about that today, but also, it's fascinating and interesting to me. And I love talking about it and helping other lawyers open their eyes to it.
Yeah. Yeah, absolutely. And it's a duh to us because I think we look at things differently. Yeah. You look at things differently. You have a different lens and I appreciate that about you. So I said I wanted to interview you and you agreed somehow. And so let's do that. So I have some questions that are kind of prepared, but obviously this will be a conversation. So are you ready?
Yes.
We're gonna start?
Yes.
Okay. All right. So we all know your titles, right? Former trial attorney turned focus group moderator, facilitator. And of course, you are a trial strategy consultant. But here's what I really want to know first. When you're helping lawyers with focus groups, what are you actually teaching them? Like, I'm a teacher, right? I am an educator. Everything that I do is in education. So like, that's my lens, right? So what do you feel like you're teaching them? Like, what are they learning that you had to learn from your own experience?
Well, I think they come to me for a focus group to learn about feedback, right? So that's step one, that's point A to point B. But I think also what I'm teaching lawyers in focus groups is a lot about communication. And when you have to listen to other people talk about you or your case, there's awesome listening skills, right? And also what's being said, what's not being said, and how to clearly set out your presentation, your point of view, your advocacy. Like, it's still something that, we can go to seminars, we can watch other people, we can watch other trials, but there's something about learning that through a focus group that is, I think, fascinating. But also when you sit back and think about, oh, there's a whole lot of brain science going on too. And that's like,
Right.
that's the next level of learning of like, okay, so we put this thing first. That would be primacy. Okay, how did that actually impact the rest of the group? And that's the fun part for me, because we get together and we talk after our focus groups and we get the feedback, right? Okay, we're hearing yes, we're hearing 51%, we're hearing this. And then sometimes it's like when you take a pause, and I take a couple days and come back and like read the transcript and then get back together with the lawyers. It's like, okay, we heard this thing over and over again. We saw this confusion, but where may it have come from? And so recently we were doing a focus group, and there was all this confusion about this, what we thought, right? Our presentation was clear.
Yeah.
We had depot clips. We thought those were clear, but there was just full confusion on this one particular point. And so I was like, gosh, what, so I went back through and read the transcript, got back together with the lawyers. And I said, we all saw this in the feedback, right? It was obvious, yes, but where may it have come from? And it was the depot clip had the very first questions, threw them for a loop, right? So the privacy, the first thing that they learned from the person they wanted to learn it from, threw them for a whole loop. And they got so stuck on that, nothing new coming in could change their mind. So I was like, so like teaching them, okay, lawyers, when you put this guy on the stand, like, do not start here. Do not start in this place.
Don't start there.
That's right. Is that, it really does make a big difference. Also, then we talked about, okay, so then how do we, for this particular point, how do we order that then correctly for opening statements? So there's so much that gets wrapped up into teaching. And I think for sure, one of my passions is teaching people. I love teaching clients how to testify. I love teaching lawyers about brain science and organizing, their thoughts and clear communication. And like, so this role for me is one of my like, oh, I get to do both. We get to do the fun focus groups and then get to teach at the same time.
Yeah. No, and what I'm hearing sort of I don't know, I mean, you're not saying it, right? But I'm kind of reading between the lines. This is what it sounds like to me when you're saying this, right? Like they're doing what they've been taught to do, but not necessarily what they need to be doing. Like, it sounds to me like in this, the story that you told them about, like how they could get thrown for a loop, that, when we go to law school, we learn how to think. We learn how to write. We learn how to write in this way, IRAC, crack, whatever. And that's when you're talking to other lawyers. But when you're like in front of a jury, you're not in front of, or in a focus group, right? Like you're not in front of other lawyers necessarily, right? Like, I don't know. So it seems like, I don't know what are lawyers taught to do that you think is actually the opposite of what they should be doing? Is that a coherent question? Yeah.
Yeah, no, I think people, again, I am 100% definitely guilty of this. And that is like getting into the nitty gritty. Law school teaches us get in there, get in the nitty gritty, investigate, find every fact, find more facts. Oh, that leads to more facts, like gathering up all our little bitty details and then like showing our details. Like that's like, oh my gosh, look at this thing. And other lawyers go crazy for it, right? Of course, like,
right.
But when it comes to communication and talking to a jury or even talking to a judge or a mediator, you want to get that 30,000 foot view. And that's where it's like, whoa, that focus group can bring you around to that, like what you've been missing. And so that's where, we get taught this, get down to that dirt, get down into the weeds, when really we need to be pulling back and looking at the 30,000 foot view, and communication wise and clarity, and what really matters to people in the long run.
Yeah, that's really interesting that you're saying that, because I mean, it makes sense. Like, I know this intellectually that, I mean, look, I did multi-district complex litigation and class actions for, I don't know, 12 years or something, right? Like, I was in the 9/11 litigation. So, like, you want to talk about complicated? They made everything complicated. You're dealing with insurance defense. You're dealing with all kinds of people who are just trying to like muddy the waters in the hopes that if they muddy it enough, then your argument will sound more coherent to another person's argument. But at the end of the day, I think everyone appreciates clarity. Like, everybody appreciates being straightforward and having the big picture. So you think so if I'm hearing you correctly, so you're saying like the real problem actually is that they're going too deep, too soon, too fast?
Well, no, I think, as like, from my background, again, being personal injury plaintiff side, like, we wanted to get every detail, make sure we have everything possible, and then put things together. And there's nothing wrong with that. I think, one, I
think it's fine when you're preparing the case, right? Of course, you need to do that when you're preparing the case.
Right. And then when you, though, need to turn and start talking and taking depositions and turn and put together that mediation, like, you really then need to be stopping and backing up and taking a different point of view at what you have versus using your lawyer lens.
Right. I mean, it seems like, can lawyers stop doing that? I mean, is that something, I mean, yeah.
I think, I mean, it takes obviously a very curious person. It takes a person who wants to keep learning. And that's where you have lawyers who go to every CLE and they buy every book.
Right.
And, you can do all those things, but at some point there's always going to be just a little bit of a limitation because you're still stuck in your own brain. And that's where gathering a focus group up of non-lawyers. Okay. I always get lawyers like, well, I went down the hall and I talked to somebody, or my wife is the best focus grouper. And I'm like, okay, all these people are totally biased. Okay. Like, no, I promise she's not. Right. Of course.
Right. Of course.
like, no. Got to go get those non-lawyers and give it to them and then see what they give you back.
Yeah. Yeah. I like this a lot. It's not even just you changing your own, not even changing the way that you're thinking about it and who you're getting the information from, but also changing in how you're communicating the information to begin with. Because, I mean, and this is the part that's always been very interesting to me, sort of watching you in this focus group world, is, I'll say interesting, but I mean fascinating, right? Of the sort of the realizations and the sort of light bulbs that go off. Like, when you're sharing all these stories, I'm like, yes. But they wouldn't have had that any other way, right? So you're teaching them communications skills, right? Like, it seems like you're teaching them how to look at things from a 30,000 foot view while also paying attention to the details. But it seems like they don't have to it seems like what you do, I don't know, and you can correct me, right? But it seems to me like what you do is you give people the opportunity, these lawyers, these plaintiff lawyers, the opportunity to only focus on the things that actually matter, as opposed to focusing on all of the things and trying to shove all of the things in because you don't know what will matter. Does that make sense?
Yeah, no, I think that's a very good way of doing it. I mean, the best example I can give you is lawyers come to me all the time and they've got, here are the 10 things that are most important to this case.
10 things.
10, that's right, 10. And I'm like,
I got like, I've got like 7 MSDs waiting for you,
Right. And so I'm like, 10? Okay, that's a lot. I know that lawyers may be listening to this and be like, what's wrong with 10? Like, that's a lot. Like, think about our brains and how what we can hold in short-term memory is really like 3 to 5. That's why when you hear so many people talk about it's the rule of threes. So lawyers come to me and I got 10 things. And I'm like, and listen, I get it. I have to learn. I have to watch it and then learn it. If somebody just came to me and said, I have 10 things, Elizabeth, and I told them, listen, you're just gonna have to pick 3. They're not gonna take my word for it. And that's okay. Like, again, that's our lawyer mindset is, well, wait a second. I want to learn, I want to learn this. And I appreciate that. And so that's what we put together a focus group. And it's like, okay, here's your 10 things. What they get back to you, so it is fun to see okay, we do pay attention to the nitty gritty and the sequencing. And then, but we also know you're going to have to let all those, let's get down to the most important things and let some of these other details go.
So I guess that kind of brings me back then to the question that I had earlier, what people are doing, what lawyers are doing that they shouldn't be doing, that they were taught to do. They're taught to pay attention to these 10 things, these most important things, but that's what an MSJ is for, right? This is what a summary judgment motion is for, to really get to all of the things so that way you only have a couple of things that you're actually bringing in front of the trier of fact. So it sounds to me like litigators should actually, instead of focusing on all of the things that they think, they should be trying to figure out how to figure out what actually matters, right? I don't know, let's pretend it's me, right? So I said, I said it earlier, I spent over a decade doing multi-district plaintiff class actions, complex litigation. So if I had reached out to you then, right, God, and let me tell you how many times, every time, Elizabeth, I'm like, where was Elizabeth when I really needed her, right? And I don't litigate anymore because I live on 2 continents, right? But if I did litigate, you would be doing all of the focus groups for all of the things, right? So, but if I had reached out to you then, what would you tell me to do? To do this the right way instead of the way that I was taught, because we're not even taught how to litigate in law school, right? We're just taught how to think in law school, depending on where we work and where we internship, have an internship or whatever. That's how we learn to litigate. And if you learn under people who don't do it great, you're also good. It sounds terrible, but you know what I mean?
You might have some bad habits.
Right. Exactly. You might have some bad habits, and that's okay. And there's nothing wrong with that. We can change bad habits. We can change habits, period. Yeah. But I don't know. Yeah, I don't know. These are my thoughts. Yeah.
Sure.
Pick Elizabeth's brain, because I think it's important for people, people who are listening, your listeners, to understand how your brain works, right? It's very easy, I think, for us to say, okay, these are the things that you should do, X, Y, Z, but understanding why we should do them, I think makes it, that makes a difference too.
Sure. Right. And I think one of the things, whether you're in multi-district litigation or whether you have a car wreck that has maybe a little bit of a different flavor than your usual, ran into the back of somebody. You want to be, as a lawyer, you want to be efficient with your time. So we want to use our time, our money, resources, our case expenses very wisely. So what I encourage people to do is, okay, then get on the right path right out of the gate. Don't wait until mediation, which would be after all the written discovery is done, after all the depositions are taken, to then do a focus group and learn, oh man, they care about that claim and they care nothing about this claim that I have created. Because again, I have plaintiff's lawyer here. When I had a lawsuit, it was what claims can we throw in there? And all right.
Well, yes,
and
of
all
course.
the defendants, right.
In the alternative.
That's right.
In the alternative.
Then you create this massive, all this discovery you have to do. And then you've got to harangue and manage all these opposing counsels. And so there's just a whole lot of energy suck if you'd done a focus group before you filed.
I was literally about to say that to you. I was so actually it seems like the time to do a focus group is before you file. So you actually understand what people are thinking and what is actually going to be the issue. Sorry, I didn't mean to steal your thunder, but I just got really excited.
It's you want to go down the path that is least resistance. And, I have a lawyer that I've been working with for easily 5+ years, and she gets it. She comes to me and she's like, I got kind of an unusual one with a bunch of defendants. We could chase all these rabbits, do all these experts, or let's just run a 1-hour focus group and see where they go. And that's going to really help me at least fine tune things. And then we'll come back and do, so getting that done early to know Do they give one rat's patootie about whether the FMCA, SCCA application is wrong?
Yeah.
Like, do they more care about the training, or do they more care about the supervision? Or, let's take an employment case. Like, okay, in an employment case, you may not have the total employment file until you actually file a lawsuit to discovery. That's okay. You still have your client's side of the story you need to test, right? So It's one of these things where you can easily figure out and navigate a little bit better and save yourself some time and energy giving targeted written discovery, knowing, okay, for depositions, which questions to go, which angles we need to get in and put in the testimony now versus thinking like, oh, geez, here we are before mediation. Here's just a whole other thing that they cared about. How do I now create that at trial?
Right.
When, we've been taught, don't ask a question you don't know the answer to at trial. You're going to have to kind of be dancing around and doing and that makes people nervous.
Yeah. Well, it seems to me like you could just find that out beforehand and then you won't have that problem. But yeah, I mean, two things. One, to your point, we're taught not to ask a question that we don't already know the answers to. So we will never ask a question that we don't know the answer to because we're afraid of being told what the answer is if it's an answer that we think it's not supposed to be, right? Like I think lawyers, I mean, we're human. We have egos. I have an ego. I know who I am in the courtroom, right? Like I know how good I am, but that doesn't mean that I'm not wrong or that I can't have a different perspective. And so it sounds okay. So that's number one. Number two. So you're mentioning this client that's been like bringing focus or requesting focus groups sort of ahead of the game, ahead of the curve, we'll call it. So in that instance, what is she actually looking for? Like, what does she actually want from you? Is she trying to figure out how to craft her petition? Or is she okay?
No. I mean, again, lawyers know how to do that. You're not coming to a focus group to figure out how to craft a petition. Like, for instance, she had a particular injury that happened at a workplace. So we got employer, we got premises owner, we got the property management. There was a construction company. She had 4 to 5 different defendants she could have chased.
Plus all of their insurance.
Well, right. Then, who do you need to chase, right? Who actually has insurance? So then it becomes, okay. And again, thinking through just the cost of all that, right? So there's those 5 people, getting all those people served, doing discovery, getting there, like that would have been a significant endeavor versus learning from a focus group right off the bat. You know what? Everything was on the employer already. There's workers' comp. Like the chances of this getting past, getting to a jury, and then it would have been really, really difficult and cost a lot of money, a lot of experts and time. And so that allowed her to make the decision of like, okay, if we're going to do this, here's the 1 or 2 defendants we'll go after, and then we'll come back and do a focus group. There are other ones where she comes to me and she says, okay, here's what we have so far. She does sometimes first party insurance. Here's this claim we have for this house fire, right? Here's what we know so far. We just need to know, like, okay, where are the holes here in some of the story? And so a lot of it is just trying to kind of figure out which claims. Is this a bad faith? Is this contract? Is this, so what kind of claims should she kind of go after versus trying to throw the kitchen sink at it?
Yeah.
Okay. And sometimes it's a matter, like mostly it's like, do they care? Yeah. Do we even care about what happened here? And a lot of times, sometimes they come back and they like, we don't care what happened here.
Well, and it also seems like what we think, I don't know, it seems like what we think is going to be the thing that the case turns on isn't actually the thing that the case turns on. But I think it seems like in a focus group, you could then test to see if that is the thing that your case turns on, right? Like if this is like, you think this is your smoking gun, but then it's not. I mean, does that happen a lot? I mean,
let's be real. Like most lawyers think they're about 3 to 4 smoking guns. Okay. When there really might just be one.
If you're lucky.
But, yeah. I mean, and sometimes what happens is like you want this to be your case theme. You want the theme to be about this lie that happened. But maybe you're not really sure how to develop that. Like that's a great thing to have, like, okay, I want to develop this. I've seen it in deposition, take it to a focus group to figure out how then to really amplify and develop it. versus thinking, I got that in deposition. That's gonna be easy peasy breezy for trial when
Right.
it really needs a little bit more development. So definitely, people's theories and smoking guns, like that's a great way to test out in focus group.
Okay, that's good to know. I don't know. Not that I'm ever going to litigate again because, I like living on two continents, but it's good to know. Well, it's also helpful. But also, I know a lot of lawyers and I'm screaming your name from the rooftops all the time. Like, do you do focus groups? Do you know Elizabeth? I do. I'm not ashamed to admit it. So I have a burning question. Can I
Okay.
switch just a little? Can
Yeah,
we
let's
switch a little
shuck
bit?
and
Okay.
jive. Let's do it. Let's do it.
I'm curious whether you like when you were litigating, did you use focus groups? Like,
Absolutely.
oh, you
Yeah.
did.
Oh yeah,
Oh,
absolutely. Yeah.
oh, I didn't
So,
know.
oh
I
yeah,
didn't
no,
know. Okay.
absolutely. Yeah. No, this was not, when I became a lawyer, I really wanted to be in the courtroom, and I was very grateful to find, the law firms that I did work at, like that's exactly what they were keyed on doing as well. Let's try cases. Let's get in the courtroom. So that's kind of where it set on a path where we in the same value. Let's get to the courtroom. Let's do that, and then really being introduced to it through work, and then through CLEs about how to do focus groups. That was like the reptile theory, and really walking through that kind of case template, and like loving it, doing it while I was working with others. And then when I opened my own law firm, like absolutely hands down was like, I love doing this, but we're definitely doing this for my cases because it's fun. I enjoy doing it. And, I need to use this or I'll lose it.
Yeah. 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 No, okay. Thank you for that. Yeah, because I didn't even know focus groups for lawyers existed until I met you. Right.
Oh,
Like I mean, I knew focus groups existed, but when I think of a focus group, I think of like, a Doritos ad or, like
yeah.
I think of people sitting around eating pizza going, oh, this is terrible pizza. Oh, it's, whatever, I really like this pizza, whatever. Like I think about that sort of, I think that's sort of
Yeah.
that's always been my, my vision
That's
in my
most
brain,
people's is product related, right? Like,
Yeah.
marketing related. And then, a lot of people think, oh, focus group isn't automatically is a mock jury, but it is not.
Right. Well, this is exactly what I was going to say. I mean, obviously we know about mock trials. I mean, this is the whole I mean, look, we went, this is law school in a nutshell, right? But so it's interesting to me to hear you say that you were using them because I didn't even know that they existed and I kind of pride myself on knowing things. But it also sounds then like sort of your values then around the legal process and like strategy has really been about communication and in communicating clearly the actual issue and not kind of beating around the bush. I'm not beating around the bush when I ask this question. I'm like I'm literally I'm just trying to
No, no,
I'm
you
kind of
did.
processing all the thing. I mean, you said so much today, so I'm just kind of like, trying to yeah, pull it together.
This has definitely been a light bulb for me because I didn't know that until coming around recently to really in the past like year or two or even 3 years, like that this is what we're like, this is what we're doing, and this is what I have a real passion about, is helping people get a lot of clarity and being really clear when they present. If you'd asked me that when I was running my own law firm,
Right.
no, because I mean, I was so in the thick of things, like most lawyers are. I'm like, how do we get around this gap in treatment? How do we get around the fact that this client's not, she's not going to get that surgery, but are we going, so I was just like everybody else in the thick of trying to figure out, solve that problem for the case. What is this case value? Can people get around this other weird issue or whatever we're
Yeah.
having, And so that was really where a lot of my focus groups were. And there's nothing wrong with that, but it's kind of taken the trajectory of where I am now to really see that is what I am doing and teaching lawyers.
So as you're talking, I've got this like metaphor kind of in my brain. So this book, E-Myth, yes.
Yes.
And this idea that you're working on your business or working in your business. It seems like I don't know, and I don't know. I'm trying to draw a little metaphor here, but like you get so like you're just saying, like you get so caught up in like how are we going to get the surgery, how are we going to get this thing, how are we going to get this expert report. and we need this and we need this to prove this and this X, Y, and Z. And that's kind of like being in the case, like it's being in the case management versus it seems like there's an opportunity as a focus group to be working on the case. Does that make sense? Like
it's more of like an instruction for lawyer. You're going to come in and you're going to watch this happen. And I don't want you to take copious handwritten notes of what everyone says.
Right.
I don't want you to do that. We have
be present.
That's right. And that's what it means. Like, because most of the time, like you said, we're doing. And when we step back and then we have to observe and watch them talk about it, watch them give, their thoughts, their analogies, their phrases, you get so much more out of it because you're not in that knit grit. You're like, right. Whoa, it's really, it's fascinating. One of the biggest things people always say after a focus group ends, I mean, hands down, is that was interesting. Like, it's always the word people use. And I'm always just like, I know there's a lot going on in your brain when people say that. It's mind blowing, right? And how do you come up with this word that all the things you've just seen, your brain's just like, totally processing. On fire and lit up and excited because you're learning all these new things. You have these great ideas and like maybe interesting is the only word you're like, that comes to mind.
Yeah.
So,
yeah.
I know it means more than just interesting.
Yeah. Well, and it sounds like, you talk about, I am also the same way, like with my social workers, when we do continuing education, I'm just like, I don't want you to write every word that I say. I just want you to listen. And the things that actually strike something with you, then I want you to write that down. And it seems like these are bad habits that we're taught in law school, right? Like you have to write everything down. You can't miss anything. If you miss anything, then it could all go wrong, and like, I think I think that we've been kind of also taught from like a fear perspective of what it, like, don't mess up, don't screw up, get every single thing that you can get, but not like, if I'd known that focus groups for lawyers were a thing, and as opposed to like a mock trial, right? Like that these are two different things. If I had known that back then, I just think, man, I really could have gotten some money out of that class action. I mean, we got a lot of money, we got multi-million-dollar verdicts, right? But we could have maybe had more, like it's really, I don't know. It's very interesting to me. It seems like, you can like see all the possibilities of what we could be doing right or better in a profession. But I also think it sounds to me like, I don't know, like focus groups feel like they can, I don't know, kind of fix a lot of uncertainty. Like I think there's and to your point about psychology and sort of like human nature. I mean, if we focus on a thing or a fact or a situation, and we think, okay, this is the thing, this is it, because we're trying to create certainty in an uncertain environment, but maybe that's not the thing to be certain about. But that it seems like there's a way for us to start changing the way we practice in this way. Yeah.
And the use of focus groups for certainty, of course. I mean, I think as lawyers, especially plaintiffs' lawyers, where we have to constantly assess risk, and we are assessing risk with our own minds, with other people in our office, with past cases, past verdicts. Like there is a risk assessment you can do, but at some point it does come to a place where you're going to need to ask the people who will decide to give you some certainty. Right. And of course, people come all the time for certainty about the case value, certainty about, well, which way, how will they apportion liability, certainty on witness credibility. And like, so certainty is definitely one of the things people walk away with, one of the intangibles people walk away with, along with confidence. I mean, there's a lot of confidence that comes out of having people talk about your case, listening about it. And again, feeling confident you put it on the right track, or confident you can get it on the right track if you need to.
Yeah. 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 All of this makes crazy sense. And then again, I've learned so much. I mean, we've known each other for years and still I've learned more things today.
I hope you've enjoyed this fresh perspective on the show as much as I have. Being interviewed by Sheila has been both illuminating and slightly terrifying in the best way. In our next episode, we'll shift gears and continue to explore how I work with lawyers more effectively, Plus, we have some surprises from Sheila up her sleeve. Thank you, Sheila, for this incredible conversation. If you are curious about what she does, you can find her information in the show notes. And don't miss out as part 2 of this conversation drops in 2 weeks. You can follow on your favorite podcast platform not to miss it. Thanks again.